Years of experience as a legal counsel dealing with patents. As always, anyone can enter a question at any time. So if you just have one, just enter in the chat. Now let's welcome Digger Chen on how to obtain a patent.
Hello, everyone. Good evening. Could I share the screen?
Yes.
Okay. So today's topic is mainly on patent. As you know, patent is one of the categories of intellectual property. So I don't know how many of you familiar with we call IP, intellectual property. Does anyone can name some intellectual property categories except patent? So by the way, while I am talking, you guys can always interrupt me. You can raise a hand, or you can in chat write some questions, or you can just interrupt, just speak out, fire a question. So I don't mind if you do that. Oh, somebody says copyrights. Yeah. Do we have anyone else? Any other categories? That's good. So what we're going to do tonight is to go through pretty basic intellectual property, just like what kind of intellectual properties do we have? And then we focus on patent. Just give you some basics of patent, how we relate it to our potential inventions, how to obtain patents, etc. All right. So let me see, how do I move to next? Oh, here you go. So this is a Coca-Cola bottle. I know everyone had Coca-Cola, but did anyone had this kind of Coca-Cola before? With a bottle, still some stores have that. So what kind of intellectual properties do we see here? I see a chat. Brand. Oh, 30 years ago. Coca-Cola, yes, probably more than that. But in some stores, we still have this kind of bottle Coca-Cola. You can see brand, Coca-Cola brand, we call trademark. Do we see something else? Anybody? You can put on chat, you can just speak out. I like to hear you. You can unmute and bottle shape. Yes. Bottle shape. But what kind of intellectual property is this? If a bottle shape? Bottle cap design. Yes. What kind of intellectual property do we have? All right. So most obvious is I'm trying to move to next one. Oh, here you go. Trademark. We call you can see trademark Coca-Cola. This is stylish writing and the shape and a kind of red background white Coca-Cola. I mean, certainly Coca-Cola has a lot like Coke and many other trademarks. So we can see trademark here. At least this Coca-Cola has a trademark. Other people cannot put in some kind of liquids there and then put Coca-Cola name trademark on the bottle and sell it. That's called infringement of Coca-Cola's trademark. Does anyone think of trade secret? Coca-Cola formula. The company said they have trade secret, the secret formula, because no one can not in the public. So that's why they have exclusive formula. So everybody want to taste the Coca-Cola taste. By the way, there are many experiments they did. They put all different kinds of Coca-Cola Coke product related and similar products for people to taste. Nobody can taste, oh, this is Coca-Cola. This is not. Probably a little bit different taste of Pepsi Cola and Coca-Cola. But if you go buy Walmart brand Coke, probably cannot taste difference. But they do say they have trade secrets. That's why they protect the formula. We have patents. Right now, people talk about two different kinds of patent. It's called the bottle shape is design patent. You design this kind of shape. So you protect it. Other people cannot design similar this kind of design. But right now, there are a lot of this similar design because the design patent expires. So that's why we have all this kind of shape have. And utility patent, somebody says the design of the cap is also a design, but also Coca-Cola does have utility patent like some tamper resistance cap when they have pressure and then they have different design, not only design, but utility patent that we want to focus on tonight to talk about utility patent. And somebody also says copyright. So let's see all this bottle, this Coke bottle has all categories of intellectual property, trademark, trade secret, two different kinds of patents, utility patent, design patent, and copyright. That's all we have. If you say IP, these are 5 categories of IP. Look at this. This is all trademarks. We are all familiar with Coca-Cola, Nike, Google, Apple, MasterCard, Samsung. They all have all different kinds of design, shape, and also importantly, trademark also called word. There's one category, word trademark, just Google, Google. Just this spelling is also trademark. Not only on this kind of like fancy design, like Nike swoosh is a trademark. And this is copyright. The related to Coke, drink Coca-Cola. This kind of statement, friendliest drink on earth. This is Coca-Cola's trademark. If we copy this, we say the same thing, Coca-Cola might find a complaint against me saying you infringe their copyright. So this is copyright. Trade secret. Somebody says there are only 2 people alive who know this recipe of Coca-Cola. Those are trademark. And Coca-Cola, the company says, oh, only a small group of people know the formula. So is it correct or not? But they have this trade secret. Design patent. So you can see here, this is one of the United States Patent Office issued designed patent. You can see the patent in this bottle shape was patented in 1915. So this is long expired. So these are kind of design patent. Utility patent. You can see here, if you can see, the assignee is the Coca-Cola company. And this patent is talk about a cap called temper resistance cap for quick disconnect coupling plug. So there's some kind of like wine bottle, but in the old days, they have this temper resistance. That patent is issued on in 1978. This is also old patent. I just want to show you Coca-Cola, all this kind of patents. So you can see, anybody knows who he is? He's the most famous marathon runner, the world record holder. But he's holding a pair of Nike shoes. So you can see this Nike shoes. Can you see all 5 categories of intellectual properties? Can somebody just say what are the 5 categories of IP? Copyrights. Somebody can type it out or speak out. Trademark, copyright, trade secret. Yeah, trade secret. Design patent and utility patent. All right. So when you see any kind of product, you kind of have this kind of thinking. Oh, there are quite a bit intellectual property related to the product, mainly for the protection of its product, so they can have business advantages to kind of sell or market their product. Okay, so now let's focus on patent. So the patent law, actually patent or copyright law, is under the Constitution. Constitution Article 1, Section 8, Clause 8. It reads, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So this is actually the fundamental basis for the trademark, for the copyrights and patents, the science and useful art. The government gave the authors and or inventors the limited time of exclusivity for their writings or discoveries, meaning inventions. So that's under the Constitution. What is a patent? A patent is an IP right granted by the government, for example, US government, to give an inventor the exclusive right for their invention up to 20 years in exchange of disclosing all your inventions, all the details, and its ultimate benefit. So if I have invention, I file a patent, the USPTO, United States Patent and Trademark Office, representing the government, give you 20 years exclusive right. That means you have exclusive right to use the invention. Other people cannot use your patent to make, sell, or just to do this product according to your invention for 20 years. After 20 years, it belongs to the public. So that's the definition of patent. And there's a patent law govern this patent. 35 US Code Title 35 is patents. So the part one mainly talk about how the US Patent and Trademark Office had this authority to govern patent and trademark. By the way, copyright is a different office called US Copyright Office. It's different. USPTO only governs patent and trademark. They are together. And then part two talks about part two and part three are most important. Patentability of invention and grant of patents, meaning what kind of invention, what kind of matters can be patented, and how USPTO will issue a patent, grant a patent, the procedure, all this. So from 100 to 212, the paragraph. And then part three mainly talk about protection of your patent rights. If you gain an invention, you have a patent. If other people infringe your patent, how do you go about it? So there's called patent litigation all over in the United States. It's very, very vast field of patent litigation because people always fight against each other on business work. And part four talk about patent cooperation treaty because patent is nation by nation, each nation. There is no such thing called world patent. If you file a patent, you cover the whole world. No, you have to go to each country to get your patent. So each country has its own patent right. But there is called treaty among over 200 countries. They come together to have a cooperation treaty, how we coordinate each other. Because if I file a patent and then for a certain period of time, they hold you in the plate, then you can have choices to how to decide which countries you are going to apply for your patents. They give you some a time to consider for the business purposes, because if you file every 200 countries patent, the cost will be very, very high. And then at the end of the day, if this patent doesn't produce any money, then you already lose a lot of money. So the business will have to decide whether or not to apply patent in other countries or in what countries, how many countries do you do? So that's all cost related. And part five is talking about a Hague Agreement International about the industrial designs. So those are different things, a little bit out of the scope that we are talking about tonight. Does anybody have questions? Do I have any questions? No? Or is it bored? Or okay, let me get on. So there are a lot of great patterns. These are just some examples. Magnetic, this train, or robots, iPhone, this kind of flying machine, or this kinds of, there are many, many great patterns in the history of science and technology. So let's talk about the criteria for patentability, how to obtain a patent. So the first point would be you have to be an eligible subject matter. For example, if you find the laws of nature is not patentable, or natural occurring phenomena, I find some like a tornado kind of phenomena, or abstract ideas. Oh, I have idea then and can invent a flying machine to the moon in 2 hours. Abstract ideas. I have a great idea to cure cancer. Those are abstract ideas. Or you have idea to build a robot that can really do some great things, but I'm not sure what kind of great things do we have. So those are ideas. Ideas literally cannot be a pattern. The ideas have to be realized in we call a machine or a medium. So you can describe how your ideas being realized, being invented, being practiced in a computer or in machine, in robots, in certain kind of media. So, but there are some gray areas, for example, software applications, DNA technologies, if anybody interested in biology. For example, nowadays, like mRNA vaccines, there actually is related to DNA technology, but they have to use in certain, have some product or use in the product. Software applications as well. A pure software cannot be a patent, but using a software in certain application can be patented. So this is very important. So we need to kind of understand in a big principle what things can be patented, what things cannot be patented. Not only so, the second criteria is have to be called useful. So useful, that means this patent, if you find something like perpetual motion machine, those are not practical, not useful. So it's cannot be patented. The third criteria is have to be novel. We call novel. You have the novelty in there. Something, your invention, nobody has done it. Nobody has written about it. Nobody has published about it in anywhere in the world or in any kind of language, regardless you know it or not. If somebody in Ethiopia already has published in Ethiopian language, they publish in Ethiopia, but you would never know that. You came up same kind of invention, but it's later than his. If USPTO find this, or even you have have this patent and later on people found out about it, you are not eligible to have this invention, to this patent belong to you because other people has already invented. Also, the fourth criteria is a little bit difficult to understand. It's called non-obvious. Non-obvious means people in the field think of your invention is like no-brainer. Everybody can think of that. Everybody knows that, but you write it out and then apply the patent? No, because it's so obvious. So this is kind of, it's not hard standard, but USPTO, the government always have this objection, say, hey, your invention is obvious. Then you have to argue, this is not obvious. People cannot think of that. Why? You have to argue with them. And then the last requirement is you have to sufficiently describe your patent, how you come about that. You give examples. How do you put software into the machine and this invention be practiced? So you basically have to disclose all the details of your patent. Then you got a patent, you have 20 years exclusivity, and afterward, people can, based on your description, can do the same thing. So that's the basic five criteria for patent. So let's look at it one patent just to go through. If you have any questions, you can always put on a chat or just speak out or raise your hand or do whatever, okay? And then host can stop me, we can discuss. Or you can save time for at the end, you can raise your questions, okay? So let's look at it. I just gave a one. Let me see. Share. Let me stop sharing and then share this pattern. Wow, I see so many people got on. Okay. Can you see the screen?
Yeah, we can see it.
Okay, great. Let me move all the way up. Okay, so this is a pattern. So how do you read a pattern? Basically is quite simple, okay? This is a United States patent. And there's a patent number US 8047889. The date of patent is November 1st, 2011. That means the patent is issued on that day. And the title is called Block Set and Managing Method thereof. Inventor is a Japanese guy. Everyone in the world can apply US patent in the US. It doesn't, you don't need to be US citizen or anyone in the world. Assignee means he's an inventor. He assigned a patent to this company, a Japanese company. This company owned this patent. And the other details I will not talk about because this is a little bit out of our topic, not basic. And patent filing date was December 20th, 2006. You can see the patent date is 2011. After 5 years, get this patent. Those are this is a complicated, a little complicated. We won't talk about it, but you can see how to read those patents. and then also reference cited, so related patents or publications or related patent, they cited this. And abstract, and then a most important figure on this. So that's the first page. The second page, third page, all the pages, those are figures. Block, figure, all the figures, those boxes, and you have to describe all these figures. Flow charts. So total has 11 figures. And then we come to description. So first of all, you have background, invention. Those are background, and then summary of the invention. When you read, there's a number in there. So if we point out, okay, 45, line 45, you will see where the description is. 960, and then paragraph 4, 5, those, and then called brief description of drawings. So we can see those 11 drawings, they have title, describe it, and then detailed description of the invention. So each figure you have to describe. So the name, if you remember, in the figure, there's a lot of, see, these are like 622, 621, 620. You have to describe all this. So very detailed description, okay? All describe all these patterns, all the figures. And then you have called embodiment. So they give you example of embodiment mode 1, mode 2, mode 3. Basically, those are examples of how this invention gonna work. Now come to the most important parts of the patent we call claims. You can see what is claimed is number 1, a toy block set comprising da 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 da, da. And then number 2, number 3, number 4. So these, they have 15 claims. Claims are the center, essential to the patents. When we talk about infringement of a patent, meaning your product reads on one of my or several, one or several of my claims. It doesn't matter how to describe it. Your claims is your right of the patent. So that's we read the whole patent like that. Those are example of one patent. Let me come back to this one. So let's take out 2 of these claims. Let's just read these claims to understand a little bit about what a claim is. This one is invention set, block set. His invention basically is a block set comprising, we have 1, 2, 3, 4 elements. It's combining basically three things, at least 2 blocks. So 1 or 2 blocks, or more than 2. Say at least 2 blocks, meaning you may have 3 blocks, you may have 2, at least 2. And a container box for storing the 2 blocks. So these are 2 elements, 2 blocks at least, and a container box. If you file a patent claim, say A block set comprising at least 2 blocks and a container box for storing the 2 blocks. Nowhere in the world you can get the pattern. You have to be more, something else, right? So wherein then more describe of this pattern, meaning you have to narrow your claims. Each of the 2 blocks include a wireless chip. Wow, something in there. The blocks include a wireless chip. And then further describing, the wireless chip has a memory which stores an ID number. And the container box, it also described, container box includes a reader for obtaining information of the wireless chip. So that it talks about how this container box in relationship with these blocks, receiving information, serving in the internet, blah, 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 blah. These are all the 4 elements, each element of this claim. So this is one claim we call independent claim. That's not dependent, depends on other claims. So independence, when you have a product, how do we determine a product infringe this claim, for example? So you will read this, okay, does this pattern has 2 blocks or 3 blocks or 4 blocks or 10 blocks, at least 2 blocks? Oh, okay, we meet first element. Second, does it have container box? Yes, we meet second element. And the third, does it have a wireless chip? Has a memory in there, identification number, da, da, da. Oh, the third element also met. And then fourth element, we see the products, how they communicate the container box and communicate the 2 blocks. If all these 4 elements are met, then we can decide, we can say your product infringe my claim here. So that's very basic patent infringement. Now, let's look at claim 13. Can you tell the difference, dramatic difference from this claim, of this claim from the claim 1? Can somebody point out? Claim 1 talks about a block set, a product, or if our invention is a drug, is a composition or chemical product, or a product or machine. So this is claim 1. A block set is a product or is a machine or apparatus. Claim 13 is a method. It is called a managing method of a block set. So here is a dramatic difference. In the patent world, there are 2 different kinds of utility patents. One we call product or composition claims. The other invention called method invention. If you find a inventors methods, a new method to do something, it also can be patentable. So you have to understand, it's not like, okay, I have to invent a really big machine or a apparatus or a composition in order to obtain a patent. A method, a novel method of doing something or using machine is also an invention. So this one basically is related to the block set because it's in the same pattern. And managing methods of a block set, including at least 2 blocks and a container comprising the steps of. So see, you can see the method claim is quite different. It's the steps of. How do you do that? Obtaining information, communicating, storing, and display. Also has 4 elements. So in a patent litigation world, if you have some kind of machine doing this exactly reads on these 4 steps, your methods also infringe my patent. So it's the same principle. The take-home message is patent is not only a machine, patent can be a method. Okay, so that's I gonna stop for a moment if you have any questions. I invite you to have questions. Anybody?
So, dear Chen, if our team design a robot and part of it, we use a new method to design the arm so that the robot can achieve a better performance. How can we search if it's possible to apply a patent or provisional patent for it?
Right. Okay. So you actually take me to the next search. So we have this basic understanding of what a patent is. Then we come to how to obtain a patent. For example, just Ms. Wang says, if we think this is a novel method to design a robot arm, how do we know this is patentable? So we have to do some basic search. So first of all, you have to understand what a patent search is and what is not. Basically, what we do patent search is not only you search the patent, you search very broadly, like Google search, anybody who has published, who has out there is a public information about this. Not only a patent, but also articles, papers, abstracts, anything. In any other languages, certainly, we don't know Hebrews, we don't know Italian, maybe just search English. You may not be able to do a comprehensive search, but at least you search something. If you find somebody already published this kind of methods, this kind of design, then it's not an invention. So what is not search? Basically, you search if something that not related to what your invention is. For example, if so the two claims, let me go back of this claim. There is invention point here. The main invention point is element 4, number 4, because 2 blocks is not an invention. Everybody has 2 blocks, can do 2 blocks. Container box is not. And then maybe each box has a wireless chip, maybe is kind of invention, but I think the key point is number 4. So that's why when you write a claim together, it does not mean every element is novice. The claim as a whole has a novelty in there. That means it's a patentable claim. Okay, so when we do search, basically, if you think this is new, novel, and non-obvious, then you go Google search. You just do wild search, keyword search, whatever. If you try to find something that prove you wrong, if you have spent some time say, hey, this is not, maybe is my methods, our methods of design is maybe new, then we can try. And then we can try write it up, called invention disclosure. You write it up, say, oh, how do I design this? And then identify 3 to 5 key features. So key features is that, and then you begin to search. Those key features are your invention point. Those are key. And then if one of the key features you think nobody has done it, then these key features can be in combination of other features, because when you write claims, you have to write comprehensively all the steps or all the elements of your product or your apparatus or your robotic arm, whatever it is, then you may obtain a patent. Then, then you have classification search. Maybe later on I can teach you how to do this. Or non-Google search, there are a lot of databases. Those are mostly paid databases that can search patent. But there's a point, a lot of people, they only do very fundamental, very basic search, and then write a patent and then file to the USPTO. Because one of the examiner in the USPTO's jobs is to search prior art for you. Prior art meaning other inventions, other publications, other disclosures that already in the public domain before your invention date. So the USPTO examiner, their job, they have a database to search on it. If they find something that is prior art, they will send you a letter say to reject your application. Then it's not the end of the world, because if you read the examiner's rejection or objection, you think inventor is wrong, you can reply to the office action saying, hey, Mr. So-and-so, Mrs. So-and-so, your rejection we receive, we think we are not agree with it. We traverse your rejection because 1, 2, 3 points. You have to bring up whatever reason and whatever your basis and your document support and everything. That's why back and forth. Then in order to obtain a patent, the examiner has to be convinced that your patent is novel and not obvious. And you have enough description and you have all this enablement. So those are basic things. So here is called public disclosure. So for example, you design a robotic arm, you use novel methods. You don't have time to write it up. And you already present it in Zoom meeting, or you published in some journal or some kind of on your website, for example. That's called public disclosure, day 0. Within 1 year, you are eligible to file a patent application. You can file a provisional application or a formal patent application within 1 year. But if you file a provisional application, that means you already reserved that date. Then within 2 years, you need to file a formal patent application. Let me expand a little bit on that. So if you think it's invention, so our student, because filing a formal patent application usually costs a lot more money, a few thousand. And if you hire a lawyer to write for you, maybe to 10,000, maybe more, because the lawyer has to spend time with you to write it up, to apply, and then to also to interact with examiners, because the examiners say, hey, you know, we have prior art, and then we search prior art, and we can say, no, this prior doesn't read on me. And examiners say, hey, this is obvious. You have to traverse, go back and forth. So it may take some time. Those file a patent to obtain a patent may be costly. Or sometimes later, after you filing a patent, you find this is not useful to me. Why I file a patent? It is totally waste. That then you already file a patent, you wasted money. So that's why we come to have a called provisional application. Provisional application meaning it's not formal application. Provisional application doesn't need to be full blown, write it up, all the details like what we have read on the example of the patent I show you. The provisional application mainly briefly describe what your invention is, but you have to describe sufficient enough, then your formal patent application is in line with that. Your formal application cannot be like new things added to it, or provisionally too abstract that nobody understand what your invention is. You have to describe your invention sufficient enough for the ordinary people in the art can understand what your invention is. You don't need to write claims. That's the good things, because writing claim is very essential, because claims are essential to the patent. The upside of provisional application is for you cost just one fee, just filing fee. The USPTO just put it on a shelf. They don't do anything for you. Just put it on a shelf. The only thing is to reserve your priority date. What is priority date? The date you file the provisional application, meaning that's the day of your invention. For example, today is January 7th, 2023. You file application and provisional application. USPTO record your date, January 7th, 2023. 2 months later, somebody came up with a great idea of exactly the same of your invention. They file a formal application. And then USPTO, for some reason, issued a patent. And then you came up say, hey, no, I already filed a provisional application. Here is the records of USPTO. So you actually win out because you predate his invention. But you haven't filed a formal application. You can wait until the January 6th of 2024. You file a patent, a formal patent application. If you don't file a formal patent application on January 6th, 2024, your provisional application automatically expires, automatically disappeared. Nobody recognizes it. USPTO doesn't do anything for you. Your application, you cannot say, hey, after 2 years, I have a provisional application, I need to file. USPTO will say no. Either you file a new application, provisional application, or formal application, or not. But there's another thing called public disclosure. if you public disclose your invention, it's also prevent others to apply application. Your public disclosure actually is also a prior art to other people's invention, but not to yours, because that's your same inventors do public disclosure and provisional application. I don't know if I explained this clear enough.
So I have a question. The
Yeah.
public disclosure, do I need to like if it's a trade secret, like I have a formula for the Coca-Cola, do I have to disclose
No.
everything?
No. So public disclosure is not you have to do public disclosure. Public disclosure is just because you sometimes in a scientific meeting, you present your articles, you publish a paper with your invention. That's called public disclosure. Or some people, they don't file a patent, they only do public disclosure just only to prevent competitors to file a patent. They think this is not worthwhile for my company to file a patent, but I have this idea, I just write it up to publish it, prevent other people to file a patent. So that's some kind of exceptional examples, but public disclosure meaning you disclose your invention in public. So if you have this invention because, for example, it's not trade secret, you have this invention, you have designed a robotic arm using novel methods, but no, you did not disclose it in public, because if you go to competition, nobody knows how you design an arm. That's not public disclosure. Only when you present it, you say, hey, number one, number two, number three, how I design the arms, then it's public disclosure. Did I answer your question?
Yes, thank you.
Sure. So what we do is basically usually say whether or not the public disclosure basically has 1 year grace period. If you disclose in the public, you have 1 year to file a patent, either provisional application or formal application. And then within 1 year, for example, today you went to a seminar, you went to a conference, you publish how you design your arm, all the details. Then somebody else file a patent before you file a provisional application. You may have argument, say, hey, I published, is their prior art, but your provisional application may not be valid because you haven't filed other people. So that's a fight. But nevertheless, let's start filing a provisional application for, say, most of the case you have, if you have this invention, you did certain search, you think your invention made it worthwhile to file an application. Then you file a provisional application. You briefly describe your invention. I can read it for you to see is this enough. And then you file it with individual inventor or a group of inventor, we usually call small entity or mini entity. I don't remember, small entity probably $300, and then mini entity meaning maybe just 1 to 2 people, company even less. I can check it out how much, maybe 100 or 200. That's it. So $300, you file this provisional application. Then within 12 months, you decide whether or not to file a formal patent application. Maybe within this 12 months, you did some search, You did some, or somebody told you already, oh, there's something already published, or you think this is not worthwhile to file a patent, so you just abandon it. You just do nothing. Then 12 months lapse, your provisional application dies. But within 12 months, if you find, hey, that's worthwhile to file a patent, then you file a US formal application called non-provisional application. Then application into USPTO, and they examine it, they did search, they sent you letter, and you kind of traverse them, you come back and forth a few times. So examiner does search and issue we call office action. Basically writing a letter, tell you, hey, your claims allowed. Wow. No, most of the time is not the case. Examiner always finds something to traverse you, to object or reject you. But in rare cases, they first shot, say, hey, claim allowed, then your patent issue. And there's an objection or rejection, then we respond to the office action. Examiner then issue a second, based on your responses, second objection. Oh, let me see. Then issue the second and reject or objection. There are all the procedures. You can recall. Move this again. You can reject objection, you can file, you can appeal, you can do a lot of things to make your claims allowed. Or in rare cases, if you have enough evidence to support your invention, usually your patent will get allowed. Only thing that if this prior art is too strong to really stand on the face of your invention, then you have to give up. So that's the main procedure of filing a patent to obtain a patent. So since you are very smart, with some guidance, maybe if you have time, you can do it by yourself. But if it is complicated applications, I will recommend you to hire a professional, either patent agent or patent lawyer, to do it or do it together with you. So sorry, I a little bit over the time, but if you have any questions or anything you wanted to discuss with me, not robotics, but IP law or patent, you can always email me. Just introduce yourself, your who so-and-so, and then if I'll find the time to respond to you, okay?
Okay, thank you,
That's it.
Digger Chen, for thank you, Digger
welcome.
Chen, on how to obtain a patent. Thank you for your time. If you have a question, please put in chat, as we will answer questions now. So the first
I already
question
saw the
is,
question. Okay.
yeah,
Okay, you can read it for me.
if any of the kids want to become an IP lawyer, do they need to get a PhD first?
That must be from a parent. Oh, yeah. No. Okay, so patent lawyer actually, there are two kinds of IP lawyers. One kind of IP lawyer, they have certain technical background. For example, I have medical background, pharmaceutical, medical, biological background, but I do a lot of high-tech litigation, even though I don't know much about software or telecommunication or robot. But So there are two kinds. One kinds of IP lawyers, they have technical background, and depends what kind of technical background is. Usually, if you are in the pharmaceutical, biological, or chemical fields, usually those lawyers have PhD degree. But for the technical, like mechanical, electrical, computer, usually they don't need to have a PhD. So those are IP lawyers with technical background. The second kind of IP lawyers, they don't have any background. They are liberal arts background, English, history background. What they do patent litigation. Patent litigation is actually more exciting. They actually, in the federal court with teams of other IP lawyers, with technical experts. They hire technical experts to do expert witness, expert reports, but they are good on litigation, how to present the case, how to talk before the jury, how to do all this. So there are two kinds, one with technical background, one without. So either one is fine.
Okay, thank you for your answer.
Sure.
So is there anyone else that have a quick?
Usually without 3 questions, my talk is very, very bad. I only had 1 question so far. Oh, I had 2.
Okay, so I have a question. So
Sure.
why do you think patents only last for 20 years?
Yeah. Why do you think patent lasts 2 years? It's a trade-off. Okay, so is balance between government and the invention. So this is the patent law under constitution is basically to promote science and technology, to promote advance of science technology. For example, if you have invention, the government give you paternity or 50 or 100-year invention, exclusive right, then other people don't have motivation to do further. You have this monopoly for 100 years. It's too long. But if I don't give you 20 years, nobody has an invention to have motivation to do any invention. So that's kind of balance between the government and the private inventors. Is there an age requirement for patent application? Patent application award? No. Anybody can file a patent. Any individual in any nationality. If you're 100-year-old, you think it's still invention that you can still file a patent. We don't usually call award a patent. We call grant a patent, or patent is issued, patent is allowed. So you file a patent, so USPTO allowed you to have patent. Then you file some fees and patent got issued. And also USPTO can grant you a patent because you apply for it. Yeah.
I have another question. It's a real thing. It's a real story. So I know a guy. He's a U.S. citizen, and he used to work in a tech company. And his company has a patent for a kind of product. And he know this patent is only patented in this United States. So he went to China. He built a factory, and produce those product in China and export it to Africa.
Mm-hmm.
So is that totally legal because the patent is only in the United States?
It's legal. It's legal in the sense that your patent, this patent only within the jurisdiction of the United States. It's unethical and also illegal for this individual because he knows the patent. He may breach the fiduciary duty of the company. So, but if he does not have this fiduciary duty or have any contract with the company, he may be legal. It's totally unethical because I have a lot of occasions of in the old days, maybe 10 years ago, when US and China are really, really good relationship. And then we have a lot of US companies go to China, have our Chinese people to manufacture for them, and then sell it worldwide. And our Chinese folks always think, hey, why don't you file a patent in China? And the guy in the US guy say, hey, no, it's okay. Well, we don't need to because of our sales, I don't have time to do this. And then he, unbeknownst to the US counterpart, he filed a patent in China. He got a patent. And he said, bye-bye. I will not do contract with you. I have my own product. I can sell. You cannot sell your product in China because I have patent. So it happens quite often in the old days. So a lot of time U.S. Companies they understand this. They file U.S. Patents in China because filing patent in China is not that expensive. And also they have, when I talked about the patent law, we have called Patent Cooperation Treaty. China is a member of PCT, Patent Cooperation Treaty, called PCT. So usually if I have a very good invention, I not only file patent in China or in the US, I also file a PCT application. PCT holds your application in the PCT platform. And then within 26, 28 months, more than 2 years, you can decide to file patent to China, to Germany, to France, to whatever country. Because you have to, if other people file patents in China, you can say, I already have PCT application before you. So that's the way of preventing others to file a specific patent, same patent applications in a specific country. You have PCT treaty to prevent this happening.
Can I ask you a question?
Yes. Far away.
Yeah, I have one question regarding the fee. You know, you said for one patent, the first time you need to pay $300 for the application.
Provisional application, yes.
Provisional. How about the formal patent? How much?
Formal patent application has 3 parts. One is called application fee, the other called examination fee, the other called search fee. There are 3 parts. Usually, depending on how big, there are 3 categories. Usually 2 categories, small entity or large entity. So those fees usually for small entity filing and a formal application, you have to pay 3 kinds of fees. Usually, if I remember correct, they kind of increase in recent year. I haven't done utility patent. Usually our paralegal do this calculation. Probably around 2,000 to file application. Yeah.
So total is $3,000 for
Total
for
2,000.
individual, for the individual file
Yeah.
instead of big corporation. Okay, thank you.
Yeah. Yes.
So it's other than this $3,000, do you have any like a annual like maintenance fee something?
Yes. If you get a patent, if you get a patent within 20 years, you have 3 times, I believe is 5 years, 12 years, I can't remember, 3 years, 8 years, 12 years, 3 times you have to pay maintenance fee for a specific country. For example, if you have only has one issued patent in the US, within this 20 years of your exclusivity, you pay 3 times fee. But if you have counterparts in other countries, different country has different rules. So some countries has higher maintenance fees. Some countries just register your patent. They don't examine it. You still have to pay yearly, like every year to pay fee. All complicated. So that's why a big company, they usually either hire an outside firm or their internal team to have this software to manage all these fee structures. For example, when one of my clients has more than 100,000 patents currently, live patents. They're massive work of keep those patents alive, payment maintenance, because these patents, they are not only in the US, but in China, in all over the world. Yeah.
So roughly in the US for this 20-year maintenance, how much roughly, is
Not much. It's
not much.
probably a couple thousand. Yeah.
Couple thousand. Okay, thank
Yeah.
you.
Yeah, I can search for you, but
Mhm.
if it's specific. But mainly to obtain a patent, if it is valuable patent, you usually hire a lawyer or patent agent, certainly on your familiar with your technical field, because I probably cannot write any software related to patents or telecommunication or those electronic engineering patents. Somebody who help you to write a patent and then to help you get the patent. Because when I talk about the USPTO can object your patent, so they send you office action. We have to respond to it. We do a lot of research. How to respond to get a patent. Usually cost, in average, probably cost $20,000, including fees, government fees, to obtain a patent. And then maintaining patent, you need a couple thousand to maintain a patent, to have this 20 years. In order to have your patent generate money, usually has several ways. One is you need a patent family. So one patent doesn't really cover a good product. So usually some continuation patent, related patent. The other to generate, if you have good patent, you usually license to others. I know some individual people, they have good patents and the other company license it. So they pay you. They pay you front fee, they pay you royalties, whenever, how much, what percentage if they sell the patent covered products. So you just sit home to collect money. Certainly there are patents for our students, like you don't need to generate money, you mainly enrich your resume. Oh, you are the inventor of one of the patents. Yeah, certainly the college will like will very much like it if you are an inventor of a patent.
Thank you.
Oh, you're welcome.
Okay, thank you. The next question is interesting. What is the story about East Texas patent trolls?
Oh, wow. Someone must be interested in patent law. Eastern District. I'm always in the Eastern District. I know all the judges there. Okay, so that starts probably more than 20 years ago. There's a judge called Judge Ward. He started this patent litigation dockets. So let me back up a little bit. In patent litigation world, for example, okay, patent litigation is a federal matter. So all the dispute has to be resolved in federal courts. So anybody knows in US we have two systems of court system, right? Federal courts and state courts. State court, for example, state of Texas, we have county court, we have appellate court, we have Supreme Court of Texas. Texas court usually take care of corporation, business, divorce, or criminal cases also. Federal court only takes care of federal matters. For example, patents, white collar, for example, you violate Medicare, Medicaid law. Those are federal law. Patent law, when I say 35 USC, is federal law. So you have to have to be litigated in federal courts. So federal court, there are 54 district court in all of the United States, including 4 districts in Texas, East, West, North, and South, 4 districts. So theoretically, because our product can be sold anywhere in the US, so theoretically, you can file any patent litigation case in any district court of US. I can file in California, this federal court, in Texas district court, in Florida district court. So all in federal court in all different localities. However, so when Judge Ward set this easy docket procedure for people to file patent, people very much like it. Main reason is for plaintiff, usually plaintiff bring case to the court. So defendant has to come to this court to defend. Eastern District of Texas, Plano is part of Eastern District, but most of the time the district court is covered in Sherman, in Marshall, in all Eastern there. You know, most people there are not very educated. They are high school average. So when plaintiff bring, for example, a Chinese company to the Eastern District, the jury will hear, oh yeah, the Chinese company stole our technology. They infringe our patent. The jury probably at that time in the opening, they already decided to have for the plaintiffs. So when people file patent case in the Eastern District Court, 70% of time they win. So that's why most people like to file patent in the Eastern District of Texas, because easy, they know how to follow the procedure, how to do it, and also more importantly, they will win 70% of time.
Dr. Chen, actually,
Yes.
that's right. That's how we win. The company I work in, we use the East
Eastern
Texas,
District.
and
of
we
Texas.
win the big win. We win $50 million in that lawsuit.
Wow.
So what they did is the lawyer every day come over to our company, ask the people to learn Texan local, when
Yes.
they do the like voice recording, they have to ask you to you need to learn Texan accent before you produce
Yes.
a better affidavit, That's how we
Yes.
win. They see all this California, they are thief, they come here to steal Texas. So
Yeah,
that's
yeah,
how
yeah.
we win. Yeah.
That's why our Californian company, or not even like Chinese company, they say, hey, California company, those democratic companies, they
Yeah.
come over here and then they just stole our technology. And the defendants hire like a Californian company or New York lawyers, they have New York accents. The jury say, I don't like you. So those exactly the case, because when we hire lawyers, we have national, we also hire local counsel. That means the lawyer in Marshall, they talk in their accents. They know the jury, they know the judges. So that's why we call Eastern District used to be very, very hot. Right now, Western District of Texas in Waco, also very, very hotbed. So that's called, those are like very, very interesting patent venues. Patent troll is different concept. Patent troll in old days, so if you have patents, so I come to you, I say, hey, oh, you have great patents. Let's talk about it. Let's bring this patent to file a lawsuit against Google, against Apple, against Facebook, against all these big companies. Okay. Then we will go to court. And usually this company say, hey, who's filing? This lawsuit is so bothering. Why don't we just settle with them? Because we don't need much money to settle. If we fight, we will like 2 or 3 years is interfere our business. Maybe we win, maybe we lose, but just settle. Give them $500,000, give them $1 million. So that's we call patent troll. Patent, some call NP non-practicing entities. They use this patent to file lawsuit against 100 companies in Eastern District of Texas. And among these 100 companies, 50 companies give them each give them 1 million. So they will have 50 million. And then the lawyer takes half, maybe a third, maybe 40%. And the inventors, those patent owners get 50 or 60%. They make a lot of money. So that's why I call patent troll started. People just file like all different kinds of patents. That's why also Eastern District has like hundreds of thousands of patent cases there. So if you are interested in patent litigation, we can spend the whole night to talk about it. All right. So my talk is successful. I have a lot of questions. Probably it is time to close. Yes, because everybody needs to design, need to go to invent something, right?
Yeah, exactly.
Okay, thank you so much. If you have any questions, just email me. You know, my email is diggerchan@gmail.com. It's very easy to remember. Email me. I will find time to answer you. Yeah. Thank you. Thank you for
Yeah,
putting it
okay.
up.
Thank you for your
Yeah.
time with us this evening. And I hope all of you guys learned something. And that's all for STEM Form 6. Thank you.
Thank you,
Thank you very
guys.
much.
Good night.
Thank you.
Thank you,
Good
Dr.
night.
Chen. Thank you.
Bye.
Bye.